All right, it is noon, and I want to go ahead and get started. There's a lot of material we're going to talk about today, and I want to get moving. Hopefully, it looks like we've got a lot of folks on, and there may be some more that join. I am going to try and share my screen. Oh, Cameron, it says that participant screen sharing has been disabled.
Okay, you should be able to share now.
Oh, yep, that worked. Thank you. All right. So, yep, okay, my screen is shared. So welcome. Today we are talking about avoiding evictions, homelessness, and viral spread during the COVID-19 pandemic. My name is Carrie Dietz. I am an attorney with the Legal Aid Society, where I practice housing and consumer law. Housing, I do a lot of eviction defense, fair housing enforcement, anything involving landlord-tenant law, and consumer is quite a mixed bag of any kind of consumer protection issue. We're the largest nonprofit law firm in the state of Tennessee, and we represent as many folks as we can who qualify for our services, usually through income or sometimes by being elderly or veterans, just depending on what sort of funding sources we have to work with. And thank you so much for taking the time to join today. This is a really, really important issue. And here is a bit of an outline that lays out kind of what we're going to talk about today. First, we're going to talk about why your help, all of y'all who are on here, your help is urgently needed now and in the weeks to come. We are dealing with an eviction crisis across the country, including in Nashville and surrounding areas, that is completely unprecedented, and there just aren't a lot of attorneys available to defend tenants in evictions. And so the more help we can get, the better. So thank you for being here today. And thank you for anything you're willing to do to help support our efforts, take cases, and jump in. So I'm going to try and give you some information about what you'll need to know to be able to jump in. We're going to talk about the status of evictions in Nashville, what's going on, how things have changed, where things have been. We are going to talk about the CARES Act passed by Congress in March that included an eviction moratorium and tenant protections for certain properties. Then we're going to do a very brief overview of Tennessee landlord-tenant law, including the Uniform Residential Landlord-Tenant Act, or URLTA. Then we're going to shift to talk about some tips and strategies for defending tenants in General Sessions Court, touch a bit on how to connect your clients or people who need it with financial assistance or any resources that they may need. And finally, we will touch on how to take housing cases through pro bono matters. It's super easy, and you also will have support from legal aid if you do that. Off the bat, I want to say with this many people, I think that the best thing to do in terms of questions is if you have some questions, feel free to type them into the chat box, and I will try and take a look at those as we go along. But I've also anticipate that hopefully we'll have at least 10 minutes or so at the end when I'll be able to go back through and address anything that I haven't been able to address while going throughout. All right. So this is why it's so important. Nashville was already experiencing a housing crisis years before we were struck by the coronavirus pandemic. By 2015, Metro Human Resources data showed that about half of renters were paying more than they could afford for their housing. So really, all of the recommendations say that you should not be spending more than 30% of your monthly income on your housing, including rent or a mortgage payment, as well as utilities, everything that you need for your house. You shouldn't be spending more than 30% of your income. And even by 2015, about half of Nashville renters, which is about half of the Nashville population, are renters. They were paying more than they could afford for housing. By 2017, a Nashville resident needed to make nearly $5,000 a month to be able to afford average fair market rent. And we all know that there are lots of Nashvillians who don't come anywhere close to that. Almost 70% of Nashvillians at that same time fell into income brackets where they would qualify for or need affordable housing or workforce housing in order to be able to stay within that 30% of their income and not be cost burdened. And this is illustrated really well by this point that the data that rents increased 64% from 2011 till 2017, and during that same time, wages only went up 14%. So not only was it bad, it was becoming worse. Every day, every month, every year. Last year in 2019, there were just under 1,000 evictions filed each month in Nashville, Davidson County General Sessions. On average, sometimes more, sometimes less, but that was about the average. That's a lot. That's a lot of Nashvillians and families who are not secure in their housing and may ultimately end up being evicted. So that's kind of where we were, and here's where we are now. It's only gotten worse. The March tornado didn't help things. It displaced a lot of folks. The COVID-19 pandemic has not helped. A lot of folks have lost jobs and are still not able to re-enter the workforce because there just aren't as many jobs and opportunities for income out there. According to a news story released by Associated Press yesterday, 32% of US households haven't made their full housing payment for July yet. They may have made a partial payment, they may have not been able to pay anything at all. That's renters as well as homeowners, but that's about a third of Americans who are not able to meet their financial obligations in their current housing. It's all the more urgent because the expanded unemployment benefits that Tennessee has been distributing with the help of the federal government, those payments are set to end on July 27th or July 25th rather, which actually happens to be the same day that the eviction moratorium and the CARES Act will expire. So right at the same time, people are losing the financial support that they have had to get them through this, and there is nothing holding back their landlords from evicting them. So eviction numbers are down in Nashville, Davidson County General Sessions this year. They were pretty normal in January and February, a little lower in March, really dropped in April and May while the courts were closed for most in-person proceedings, as well as a lot of the clerk's offices were closed for in-person help. And so a lot of folks, weren't filing evictions because maybe they needed help to do it. Maybe they were afraid to go into the courthouse for fear of viral exposure. Maybe there's some confusion out there about what is and isn't happening in Tennessee and nationally. And so we think that that's definitely what's contributed to this. Certainly the moratorium in the CARES Act has kept that number a lot lower than it would have been. But all that to say, there were nearly 300 evictions that were filed in June and that are still pending as of this week. More than that, there were about 540 cases that were filed in February, March, April, or May and are still pending as of this week. So there are a lot of eviction cases out there that are still pending. More are being filed every day, and so far, June is definitely ticking back up in terms of the number of evictions filed. There were about 100 more cases, eviction cases, filed in June than in April and May combined. And so we just expect that number to keep going up. It's going to become an increasingly urgent issue. Matt Desmond, who wrote the excellent book Evicted, which is highly recommended if y'all haven't read it and are interested in learning more about the problems that we are facing as a nation in terms of housing and housing stability. He worked with the team at the Princeton Eviction Lab to track some evictions and also to create a scorecard for each of the 50 states that graded the states based on how well that state was responding to the eviction crisis we're facing right in the middle of a pandemic crisis. And Tennessee was second to last on that list, earning a whopping 0 out of 5 stars. A couple of months ago, we had half of a star out of 5 stars. Now it's down to 0 of 5 stars. You can check that out yourself at that website where it's linked, and you can check out other states and what sort of things they're looking at for that. But that just goes to show that, you know, Tennessee, now more than ever, we need help in Tennessee. And the reason that Tennessee was second to last and not last is because it was only above Texas. And the only reason we were above Texas is not because Tennessee has any better policies than Texas on this, but just because Texas has such a significantly larger population that the impact is much greater. And a really important thing to keep in mind with all of this is not only are we dealing with the economic concerns where people aren't able to afford their rent like they used to be able to, but also housing is healthcare during a pandemic. We hear all the time from experts and officials that the safest thing we can do is to shelter in place to the extent that we can. And folks who don't have a home have nowhere to shelter in place. And so that means that they're not able to do that important preventative measure to limit the spread of the virus and are often pushed into congregate housing if they can even get that. Congregate shelters, that's still really what's available for homeless folks seeking shelters in Nashville, despite some pushes from advocates and people for a long time to get them to look into using hotels that are underfilled, like is going on in a lot of other states and cities. That hasn't been happening here. So we're still talking about congregate shelters. They try and move the beds away from each other, but at the end of the day, it's a lot of people living in one place. Even if you don't have to go to a congregate shelter because you can stay with a family or friend, that's still a push toward more congregate living because you are moving in with family, friends. There's more people living there, more people interacting with each other. Many people are still having to go out as essential workers and aren't able to limit their exposure. And so even just that is a big increase in risk for viral spread. So it's a really important, not just in terms of the consequences that someone faces when they are evicted, but also in terms of controlling the virus. It's really important that we try and protect the homes that people have, make sure everybody has a home who we can get in a home, and do whatever we can to keep them living in, as isolated or at least, small population areas as they can. And so it's just, really important. A really critical point on this is that both the COVID-19 pandemic and evictions have been shown through data to disproportionately affect communities of color. Some of y'all may have seen that the New York Times came out this week with some new data that they had to sue the federal government to get access to about the disproportionate impact that COVID-19 is having on communities of color. And what they found was pretty stunning. They found that Black and Latinx Americans are contracting COVID at nearly 3 times the rate white Americans are contracting COVID. And this was true across all age groups. It was true in cities, suburbs, rural areas. No matter what they tried to control for, they still found that this data persisted. And these communities of color were disproportionately bearing the burdens wherever they were and how old they are. And that also means that these communities of color are forced into hospitalization at higher rates, disproportionate rates, and even dying at higher and disproportionate rates. Some of y'all may have seen some reporting that's come out in the last couple of weeks too about how Latinx folks in Nashville are really bearing the brunt of the coronavirus pandemic here. Pretty shocking. But they found out that nearly 1/3 of all of the positives were Hispanics. So of all of the people that they tested, of all of the ones that were positive, about 1/3 were Latinx. And so that community is just disproportionately affected by the pandemic. Evictions already and for a long time have disproportionately affected communities of color. Not only are Black and Latinx households across the US twice as likely to be renters, but certain groups are hit even harder, most notably Black women. Black women are evicted at alarmingly high rates that is totally disproportionate to their share of the population. In 2017, 56% of women of color in Nashville were cost burdened by housing, meaning that they were having to pay more than that 30% of their income to secure their home. And you know, this is all for a lot of reasons, but Black women in particular are really hit from multiple directions to set them up to be really vulnerable in these situations. There's large income and, more importantly, wealth gaps between Black women and their white counterparts and Black men. They're more likely to have children, and they also have to deal with more sexism and racism from their landlords. So for several reasons, that's a particularly vulnerable group. And I will certainly say from my experience, when we do grant reporting and have to give demographics, it's definitely the case that, you know, most of my clients are single Black mothers, Black single mothers. So, you know, that's more anecdotal, but it does stick with this data. All right, so the status of evictions, what's going on? Can people be evicted right now? There's a few different interplaying factors here as well, and it can be kind of confusing even for me, and I prioritize trying to figure this out as one of the most important parts of my job right now, much less for pro se defendants and other folks. So the Tennessee Supreme Court paused most evictions across the state in March in one of their early orders on responding to the coronavirus pandemic. After that, Congress passed the CARES Act on March 27th, which includes an eviction moratorium on covered properties for evictions based on non-payment of rent until July 25th. So you've got the federal government in there that is more limited, applying to certain properties but lasting a little longer, and then the Supreme Court, you know, had kind of this blanket prohibition on court officials taking any action to effectuate an eviction, displacement, ejectment during that time. However, that statewide prohibition was lifted by June 1st. So as soon as June 1st hit, courts, assuming they had their plans approved by the Supreme Court to start reopening and hearing cases, they could begin processing evictions. In June, what that meant in Nashville, according to the General Sessions reopening plan, General Sessions was not going to hear any trials in civil cases in the month of June, but were granting default judgments against tenants and other defendants who didn't show up. They did allow writs of possession to be executed, whether that was something that had started back in March or something more recent. And one thing that we saw in particular at Legal Aid is we heard from a lot of tenants who went to court. So they didn't get a default judgment against them, but they were pressured into settling eviction cases, either by the opposing counsel, or either by the attorney for the landlord, or sometimes from the judge. I understand that, life must be really difficult right now for attorneys who represent a lot of landlords, and they want to resolve as many cases they can as quickly as possible. But the impact of that is that lots of tenants, even if they do understand that they should have a right to a trial, they are not necessarily getting that, and being able to see that through. On July 3rd, in the middle of our holiday weekend, last weekend at 4 o'clock, around 4 o'clock, Judge Linda Jones, the presiding judge in General Sessions, issued a new order about Nashville General Sessions that included that no more landlord-tenant cases would be heard in July, and they will not be heard until August. And I'm going to go back just a second. And so what that's looking like is a little bit up in the air. I've been in court a couple of times this week. Judge Bell was on the bench. She's been, doing her best to understand and apply the order, and try to stay in compliance with it. It's very broad language, and very brief. And so I think that definitely supports a broad construction and application of the order, and that's certainly what I am advocating for and will be advocating for. However, there's 11 different judges in Nashville General Sessions on a rotating schedule, and I don't know exactly how that's going to work for each of them. Some of them may have different opinions about what happens there. There are a couple of judges in particular who I know really make efforts to make things quick and easy for landlords, and don't want people to be living for free in a property that they can't pay for, and are kind of eager to push through. I think it'll be interesting to see how this all plays out. Judge Bell was not even granting default judgments against tenants who didn't show because she was reasonably concerned that folks had seen the order and thought that they didn't need to show up. Whether that's the case next week, I can't say. So the CARES Act. The CARES Act is a federal law passed by Congress on March 27th as a part of its response to coronavirus. It included a moratorium on evictions until July 25th that applies to certain evictions. So it applies to evictions that are filed after March 27th, when the law was passed. It only applies to non-payment of rent cases, and it only applies to covered properties as defined in the Act. It's notable that because the CARES Act only covers cases for non-payment of rent, it's still been possible through this time for someone living in public or subsidized housing or another covered property under the CARES Act to be evicted for another reason, maybe another lease violation or behavioral issues. And so, certainly there may be opportunities to, as an advocate, to question whether a case that sounds like it really is a non-payment of rent case, but maybe that's just a pretext for something else that they use to file the eviction. For example, a landlord evicting someone for having a pet, but the landlord knew about the pet for a long time and never had an issue about the pet, and now he's not getting rent and wants to evict. There may be an opportunity there to kind of inspect that, investigate that a little bit. So after the moratorium ends on July 25th, landlords must give 30 days notice before they are entitled to file an eviction for non-payment of rent in these CARES Act properties that are covered. And it's really important to note that this is a preemption. This provision in the CARES Act will preempt Tennessee state law, which under URLTA, tenants can waive their right to receive notice before getting evicted for non-payment of rent in their lease, as long as it's conspicuous. 12-point font in bold, the statute says, as long as that waiver is in the lease, they don't have to give a termination notice before proceeding with filing an eviction, but they will for CARES Act properties after the moratorium ends. After giving notice, evictions on CARES Act from CARES Act properties are really going to flood through, probably starting in late August once that is up. Unless anything changes between now and then, the House in Congress has passed several bills that would extend and expand the eviction moratorium or provide other protections and relief. So far, the Senate has not given any indication that they're interested in picking up any of those, but it also sounds like they may think they will have more leverage if they wait closer till the end of July when everything expires. So perhaps something will change between now and then, but unless anything else changes, we're really expecting a wave of evictions, falling off an eviction cliff, whatever your metaphor, it's coming. Coming soon. So again, all the more reason why we would love to have y'all's support. So here's a list of covered properties under the CARES Act. I've highlighted the ones that I feel like I run into most often in Nashville. A couple important things to note: LIHTC, low-income housing tax credit properties. LIHTC properties are not usually included in things that are focused on public or subsidized housing because it's really just a different program through the IRS, but those are included as CARES Act covered properties. Another important point is that in addition to these, subsidized properties and LIHTC properties, there is also, the Act also covers single and multifamily properties with federally backed mortgages. So single family home with a federally backed mortgage, that also falls under the CARES Act if that mortgage is held by Fannie or Freddie or something like that. So how do you figure out if a property is covered under the CARES Act? One helpful thing to keep in mind is that the Tennessee Supreme Court order on May 26th requires a declaration be filed by a landlord or plaintiff in an eviction case at least 10 days before there is a hearing or trial on that eviction. It asks them to declare under penalty of perjury whether the property is a covered property under the CARES Act. And if it is, according to the Supreme Court order, it should be continued until after the CARES Act moratorium ends. You can also search online if you're not sure. ProPublica has put together a really great interactive database where you can basically plug in an address and it will tell you whether that property is covered by the CARES Act or if they're not sure. An important point about this is that those single family homes with federally backed mortgages that we've talked about, it can be really tricky to figure that out. It's not, information that's normally in a lease, and there's no consumer tenant facing or friendly way for people to access that information about their landlord's mortgage. So that can be a really tricky spot. Depending on the case, it may be an opportunity to do some light discovery and look at any mortgage-related documents on the property. You may be able to find out some information through the Register of Deeds, maybe online. If not online, maybe in person, assuming that they're open and you're able to go access it. But that's a really tricky point. So even if a property doesn't come up in that database as saying that it is protected under the CARES Act, it still may be. Either way, it's always good to check your work, figure out, confirm the information that you get from that website. All right, so landlord-tenant law in Tennessee, this is the list for all of us lawyers of kind of, where's the law, what are the laws, and what should I know? So these are some statutes and a couple of cases that I run into a lot in my practice and I think may be helpful for you. The first one is that Tennessee Uniform Residential Landlord-Tenant Act, URLTA. Those two cases at the bottom are really good Tennessee Court of Appeals cases that have really good information and explanations about what tenants' rights are and what landlords' obligations are, and can be really helpful. So URLTA basics. URLTA applies in counties with over 75,000 people according to the 2010 census. So there's a list here of those counties. Obviously that includes Davidson, Nashville. It also includes a lot of surrounding counties, Williamson, Sumner, Wilson, Rutherford. A lot of counties are covered by URLTA. If you are practicing in a county that is not covered by URLTA and you're doing housing law, you're primarily relying on common law, which can just be a little more confusing and work intensive, and there are fewer codified protections for tenants. So under URLTA, lease agreements can be written or oral. You don't have to have a written lease to be a tenant and for the URLTA protections to apply to you. Oral agreements generally create month-to-month tenancies as opposed to a tenancy for a year or a term. Late rent is capped under URLTA, and there's a grace period. So a landlord can't charge a late fee until that payment is more than 5 days late. So if your rent is due on the 1st, the landlord isn't, and you turn it in on the 6th, the landlord can charge you a late fee, but not if you turn it in earlier. It's also capped at 10% of your monthly rent. So if your monthly rent is $1,000, your late fee, if you don't make it in on the 1st of the month, can't be more than $100. Security deposits and pet deposits can be required under most circumstances in leases. A really important note, especially for tenant advocates, is that tenants cannot waive the protections that URLTA gives to them, even if it says in the lease that they do. There's a specific provision of URLTA that says that these protections cannot be waived. You can't contract that. You can't agree to do that. And so that's really important. Sometimes you will run into leases that have provisions contrary to the tenant protections in URLTA, and that would not be, that would not be effective and is open to challenge. Another important point is that landlords waive the right to evict a tenant after they've given that tenant notice that they're being evicted for a certain reason, if after they give that notice, they accept the tenant's rent without reservation. So they can accept the rent and still evict, but they've got to say at the time that they accept the rent, or give them a letter, say, listen, like, I'm going to accept this rent, but this doesn't mean that we're not still pursuing that eviction against you. If the landlord does accept the rent without reservation, then the landlord is barred from going back and evicting over the same thing that they had previously given notice for. So the eviction process under URLTA, it normally starts with a notice of lease termination. Sometimes it'll be a tenancy termination, lease or tenancy termination. How much notice, how long that the landlord is required to give, it depends on the type of the agreement, when the agreement was created, and the type of the violation that the tenant has committed. So the shortest possible notice a landlord can give is 3 days. So a landlord can give a tenant a 3-day notice only in cases where they reasonably believe that the tenant is is creating, by living in the property, a threat to the health, safety, and welfare of other residents, or risks causing damage to the property. The others, so sometimes violations are curable. Sometimes this depends on the lease, but if you miss rent, but then you're able to cure that by making rent, that would be a curable violation. And what you're normally going to see there are 7/14 or 40/30-day notices, where the landlord says, hey, you're doing this wrong. You have 14 days to cure. If not, you'll be evicted after 30 days. If the curable violation is cured, then no eviction should go forward. If it's a non-curable violation of the lease, usually it'll be 14 or 30 days. And non-renewals without a written lease, or when a lease has gone past its term and automatically become a month-to-month lease, you're looking at 30 days. And importantly, those 30 days have to correspond with a full period of tenancy. So if you pay your rent on the first of the month every month, and your landlord wants you out, the landlord doesn't have to have a reason if you're on a month-to-month lease, but the landlord does need to give you notice before a full tenancy period. So if a landlord gives a notice of termination in the middle of the month, that notice should not be effective until the end of the next month, because the tenant should really get a full term of notice in a case like that. So after whatever period it is, whatever termination period it is expires, then the landlord must go to court and file a detainer warrant. That's just the form detainer summons that is available online or through the clerk's office. The landlord's got to get that and fill it out. The detainer warrant will be set for a hearing, but it cannot be set less than 6 days after it was issued. There's got to be an opportunity for the tenant to be served and get everybody on notice of what's going on. If the parties go to court and have a trial before the judge and the landlord wins, the tenant loses, then the tenant has 10 days to move. At the end of those 10 days, if the tenant has still not moved, the landlord can go back to court, has to go back to court to get what's called a writ of possession from the court, and that is the paper that the landlord can then take to the sheriff's department and use their help to come forcibly remove the tenant if the tenant hasn't moved out. There's an important point about illegal evictions. Tennessee law is very clear that that landlords must go through this court process to evict folks. They cannot take matters into their own hands and try and force out tenants without going through this process. So if a landlord wants to get out a tenant and the tenant doesn't want to move or hasn't moved, the only thing they can do is go through that court process. So a lot of times we'll see these illegal evictions. We've been seeing them more over the last few months while the courts have been closed and or slow on processing evictions, where the landlord will shut off the utilities to the property. Maybe the landlord will come over and change the locks from the key that the tenant has. And those are illegal, very, very frowned upon, and may give rise to claims that the tenant has for significant damages against the landlord in that case. So at the end of the day, the landlord's got to go through that whole process, really cannot force someone out until they have that writ of possession, and then it's, the physical removal of the tenant and their property from the home. So some tips and strategies. When you're taking these cases, here are some things to think about. One important note is that there is no inherent enforcement mechanism within the CARES Act. So the way that I look at it is that we are the enforcement mechanism for the CARES Act. Judges are going to do the best they can, but tenants are a lot less likely to be represented. And so, if you're only listening to attorneys for landlords, you may not have the whole picture. And so make sure that everything is in line and complying with the CARES Act. Make sure that if you think you have a covered property, or you know you have a covered property, make sure that no evictions are moving forward prematurely on those properties. Make sure that the landlord in any eviction has filed that declaration at least 10 days before any trial. Sometimes this can be a way to buy a little more time, especially with pro se landlords who didn't know they needed to file the declaration. Although I was also in court a couple of weeks ago, and there were several attorneys for landlords who had apparently not known about their obligation to file this declaration that came from the Supreme Court. So that can be an opportunity to buy a little time. That declaration's got to be filed at least 10 days before the court can move forward with a hearing or trial on the eviction. Make sure that notice was provided before the detainer was filed. This will be especially important once the CARES Act moratorium has ended. And again, because it's a bit of a departure from normal Tennessee law, make sure that the landlord filed notice at least 30 days before filing the eviction, because if not, they may need to non-suit it and do it again. Another thing to keep in mind is consider anything and everything that might help offset any damages that the tenant owes. So if the tenant is behind on rent and owes some amount in rent to the landlord, there may be ways to get that number down. You want to make sure that tenants are getting credit for rent that they did pay and that they can prove that they paid. It's not uncommon to see a landlord allege that a tenant owes more rent than the tenant actually does, and the tenant can prove, no, I did pay May rent, here's my receipt. That's really important. Make sure you get copies of all of that and take a close look at that. Another thing to keep in mind is, are there any conditions issues or repair issues at the property that maybe the tenant's been trying to get the landlord to fix the refrigerator or the stove or plumbing or something. Maybe it's mold, maybe it's pests. If that's something that's going on, that may be another basis for which you can help offset the damages that a tenant owes a landlord. You can basically make a diminution in value argument by saying, hey, you know, my client was paying $1,000 a month, but look at all these pictures of the property and look how long she's been trying to get the landlord to do something about all of these issues. You know, clearly it wasn't actually worth $1,000 a month. It was worth less than that. That can bring down your damages. And there are other violations as well, especially some of those that may come in those illegal eviction type situations. Maybe the landlord, before he went to court, shut off the utilities for 3 days because he was trying to get the tenant to leave. That may be a basis where the tenant has claims against the landlord and might be able to offset the damages that way. One of the most important things to keep in mind when you are defending evictions on behalf of tenants is that it is of the utmost importance to protect the tenant's record. In a housing market like Nashville's, where there's such a lack and shortage of affordable housing relative to the people who need it, and housing prices are just going up, it can be really hard to find a spot that you can afford and that's decent. If you lose an eviction in court, you will end up with an eviction on your record. And that can basically mean, because landlords will screen applicants for when they apply to new properties, they may tell you that you're not eligible to apply even because you have that eviction. So avoiding an eviction, which is specifically in this case, a judgment for possession against the tenant, it's important to keep in mind that there are two legal issues along with most detainer actions. There's the issue of possession, which is who is entitled to possession of the property. Is the tenant entitled to stay there, or is the landlord entitled to force the tenant out and retake possession of the property? And then there's the issue of damages. So damages would be anything, the landlord is alleging that the tenant owes X amount in damages for back rent and whatnot. So those are two separate legal issues. And it's important, both are very important, but it is often overlooked how important the judgment for possession is. A lot of people think, oh, it's no big deal, I'm just going to give a judgment for possession and then we can talk about damages later, or we can get those damages down. But what that means is that that tenant will have an eviction on their record, and it will make it very, very hard for them to find decent, affordable housing without moving, especially if they are evicted from public or subsidized housing. So some ways that you can try and do this, you can ask for a continuance. There's a local rule in Nashville General Sessions that either side at a first setting is entitled to one continuance for any reason or no reason, no questions asked. And you should be able to get at least a few days, if not more, of a continuance if you show up at that first setting. I would caution against telling tenants to ask for this on their own, because I have witnessed that there is an unwritten exception to this local rule where some judges will not grant continuances on first settings requested by pro se tenants. They just won't do it. And that's happened to us a couple of times. We used to advise people to ask for continuances on their own, and until we realized that really depending on the judge and what's going on, that really may not happen, even though there is that local rule. But if you show up, if an attorney shows up, it's going to be pretty easy to get a continuance. You may be able to agree to a continuance with the opposing counsel. And there may be ways that you can resolve it before you get to court. These things you can do at court or before court. Before court, if you're not going to be able to make it, but you want to represent someone in a case that's set on a certain day, call the opposing counsel and ask if they will agree to a continuance. You can also call and start trying to settle the case before even having to go to court. One way to do that is to do what's called a pay and stay, where the landlord lets the tenant stay and catch up on the rent that they owe through a payment plan. That can be really great. If that doesn't happen, sometimes the landlord says, no, I want this person out. And sometimes it's the tenant who says, listen, this property manager hates me for some reason, and I can't keep living here. I want to get out. So if pay and stay is not an option or not desirable, you can try a mutual move out, and that's where the landlord agrees to dismiss the detainer warrant if the tenant moves out by X date that is agreed upon. Sometimes you can get until the end of the month, depending on where it is in the month. It can never hurt to ask for as long as you think, as long as your client says that they need, but most likely you're going to be getting 2 to 3 weeks, maybe more. Unless there's something that the tenant can offer as leverage. So then there is trial. If you're not able to settle the case, if you're not able to get them to dismiss it because you've pointed out something that they did wrong, then you've got to go to trial. And it's really important at this stage to prepare and have really candid conversations with your client to counsel them through this decision, the pros and cons of going to trial. And whether that's something that they really want to do. A lot of people are convinced that they're right, and if the judge could just hear their story, they would understand, but that does not work. A lot of the time that does not work. An important thing to keep in mind is that there's no legal defense in non-payment of rent evictions in Tennessee. So no matter what else is going on, no matter how terribly the landlord has behaved, if it's an eviction for non-payment of rent, and the tenant can't prove that they paid all the rent that the landlord says they owe, then there's really no way to avoid that judgment for possession. Even worse, there is the option to appeal to circuit court de novo if you lose on a judgment for possession in a non-payment of rent case, but you can't appeal without the tenant posting 1 year's worth of their rent as bond. If they want to stay in the property and appeal the judgment for possession against them, they've got to put up 1 year's worth of their rent as bond. And that just, almost never happens. Obviously, if a lot of tenants had 1 year's worth of rent around liquid, they would probably be trying to put that into a down payment on a house. So before trial, have a really candid conversation with your client, talk through the pros and cons, explain that if they do end up with that judgment on their record, it could make it really hard moving forward for them to find something else. But your client wants to go ahead, they understand the risks, they feel like this is what they really need to do, then you go forward to trial. To prepare for that, make sure you collect and at trial present all evidence that you can find on behalf of the tenant. So any rent receipts, documentation, photos of the home, especially if there are conditions or repairs issues, all really important. Anything that the tenant thinks they've gotten that you agree will help their case. Be prepared with all of that. Maybe it's a witness. Maybe there's a witness who can testify on your client's behalf. If it's a particularly tricky legal issue and you are worried about having to explain it in court to the judge, consider filing a 2 to 5 page brief ahead of time if that's appropriate. I do this a lot. I think legal aid attorneys are the only ones who ever file briefs in general sessions. But we do because a lot of times we're dealing, especially with the public and subsidized housing, the federal statutes, CFR, there's a lot at play, and that can be pretty complicated, especially for judges who aren't used to hearing those arguments. And so sometimes it can really help. Certainly, if you're in a situation where you think that might help, reach out to us, reach out to legal aid, because we've got brief banks, full of briefs that folks have used in various general sessions courts on various issues. And so you won't have to reinvent the wheel. We'll be able to help you out with that. So what's it like to practice in Davidson County General Sessions during COVID? You, your client, and any witnesses that you call under the Supreme Court order, you're responsible for making sure that all of those people have masks. I will say that so far it does seem like the court has a stock of masks that they've been able to use for folks who don't have them. But you can't guarantee that, so make sure that everybody has a mask. Look into getting them a mask if they don't. The attorney entrance, the convenient entrance at the top of the stairs, is closed during this time, so you do have to go around the corner and go in with everybody else. And that said, once you do go in, there is a dedicated lane for attorneys to go through security to the right. The same familiar faces that we would normally see upstairs are downstairs. You will have your temperature taken before you enter. If this happens and they say you have a fever and don't let you in, it's really important. Call the clerk's office right away. Tell them what happened and ask to be rescheduled. They do moderately try to keep social distancing. They are very big on enforcing masks. They want everybody to have their masks covering their face. And they do make some modest efforts at social distancing. However, it's pretty tricky with these dockets that are just really long in a lot of cases. And contrary to what it says in the General Sessions reopening plan and also on their website about limiting cases to 50 or 25 at a time, that's not really happening. What is happening is that they are limiting admission to the courtroom, so they'll cut it off and not let anybody else in if it gets too full. But then they'll go ahead and call the whole docket at 9 or 10 a.m. So if you aren't let in right away, make sure you're communicating to the security or clerks as you can about, I need to be there for my client, for my case, and just keep an eye out. So here are a couple of resources for tenants. If you're working with someone who is in need of financial aid, there's this Nashville Response Fund, a coordinated effort by multiple local groups where somebody can go online or call 211 and do one application to to apply for any financial aid that's out there from any agency. This is really helpful. There's also tnhousingsearch.org, which is a web a housing locator service managed by THDA that has really great up-to-date information about what is available, where are the openings. This I will usually give to any client the first time that we talk, because you never know when an eviction is going to end with them having to move out, maybe in only 10 days if they lose at trial. And so the earlier you start looking, the only thing you can do is create more options for yourself. So I really encourage folks to do that. And these days in Nashville, it often is quite a process and takes a long time to find suitable housing and to get on wait lists and make sure that that happens. But maybe they'll find something that they like even better and decide they want to go ahead and move. So that's another great resources. So yeah, let's get y'all taking some cases. It's really easy. You can sign up for cases through Pro Bono Matters at LAS's website. And there's an instructional video here. It's just 3 minutes, but we don't have time today because I want to get to questions. But you can watch that video to learn more about how to do that, but it's really pretty easy and self-explanatory. If you have further questions about how to sign up for a case, you can reach out to Trent. He is working with Andre Chrisman as Legal Aid's VLP, Volunteer Lawyer Program. And so here is Trent's information. You can email him, you can call him if you have questions about how to do that. Oops. Sorry, no time. All right, here's my contact information. If you have questions about a specific case that you're working on that you've taken, feel free to reach out. I've also listed the contact information for Jorge, our Nashville housing paralegal. If you are having trouble reaching me, you might want to try to reach him too, and he'll be able to track me down depending on how urgent it is. But feel free to reach out to us if you have questions or if there's anything that we can do to help out. And now I am going to stop sharing my screen so that I can check out the chat. All right. Yes, so during that June time, Erwin, in response to your question, they were scheduling detainer warrants but not having trials. So tenants still needed to show up in order to avoid defaults. What that looks like now under this new order saying that there won't be landlord-tenant cases through July, I'm not sure. Like I said, Judge Bell was refusing to grant defaults against tenants because she was concerned that they would have seen that order and thought that they didn't need to show up. I'm not positive that the other judges will go that same way. So it can't hurt to show up. If you have a question, call the clerk's office. But I called the clerk's office on Monday and asked if my case was going forward, and they basically said, oh, well, we're not really sure. Everything's a bit up in the air right now, but we don't think so. And so I was like, oh, I need to go to court. So I went to court, and I'm glad that I did, if only to figure out what is going on there. But that's one option. It can be really confusing. Common law defenses during the pandemic of impossibility or impracticability. Yeah, like I think that could be super interesting. It's definitely something that we've talked about internally, whether, you know, there might be cases where that applies. And if that's something that like you get a case and you feel like that's a defense you want to put out there, do it. And let me know how it goes. We haven't had quite the right factual case yet to try out those arguments. So I can't say how it's working, but I think I like where your head's at, Paul, and I think that that's a really great idea. Yeah, non-lawyer organizing efforts around tenants' rights. Yeah, so certainly there are some organizations that that folks can connect with. There's, Metro Action Commission, Catholic Charities, Rooftop. These are all organizations that work with tenants to help them find housing or help them navigate the process. And so that would be great too. And I didn't send it to Cameron already, but I can send to Cameron. We have a list of affordable housing resources that includes everything from emergency shelters to financial aid and those two resources that I did mention, but they have some more information about some of those groups that I will send around, that I'll send to Cameron to distribute to the group. Thank you, Kara, for that question. All right, I think somewhat miraculously we are right at time. Again, thank y'all so much for your time today, for your effort, for your energy, for your willingness to jump into this. Like I said, we are going to need all the help that we can get, and we would love to have you work with us with legal aid through our VLP program and Pro Bono Matters, and start taking some housing cases. And again, I am available as a resource to anyone who does. If you have questions, or you're looking for a brief on a specific sort of thing, let me know, because I can probably help. All right, well, thanks everyone. It's 1 o'clock. We're gonna end this, but if you have other questions, feel free to shoot me an email, and I look forward to talking to more of y'all in the weeks to come. Everyone take care.